Hi, everyone. Thank you for joining us today for Constangy's webinar, Colorado Privacy Compliance Check-In. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters will leave some time to answer your questions. This program is pending CLE credit in Colorado, California, and New York. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow afternoon. I'm now going to turn it over to today's presenters, Jordan and Julie.
Thank you, everyone, for joining us today. We're really excited to dive into yet another state and their privacy law. It feels like every day we have a new and exciting state that is entering the privacy regulatory space. And so today we are going to be taking a look at the Colorado Privacy Act. And specifically, we're going to walk through the requirements within the Colorado Privacy Act, but then also talk about how they compare to some of the other state privacy laws, as well as some of those international and federal laws that we're seeing. But we're going to give a little bit of an overview of the data privacy landscape. Everyone comes into this at a little bit of a different perspective, take a look at those state privacy laws, and then really get into what are we seeing in Colorado. So just really briefly wanted to introduce ourselves as the speakers today. My name is Jordan Fischer. I'm a partner out of our Philadelphia office in the cyber team. My background has focused really extensively on international privacy laws, and specifically the European Union's General Data Protection Regulation and the United Kingdom's General Data Protection Regulation. But I really am so fortunate to work with clients that take us all over the world, whether it's South America, whether it's within the United States, Canada, Asia, as well as the European areas, which really has allowed me to have this cool perspective on sort of what's going on within the privacy landscape. And I'm really excited today to be joined by my colleague, Julie. Julie, I'll really let you describe your background and your biography here.
Great, thanks, Jordan. My name is Julie Keersmaekers. I am of counsel at Constangy, also on the cyber team, working closely with Jordan and our other colleagues. Really, my focus is helping clients build their information security and data privacy programs or enhance what they already have in place. Working with a broad range of clients in various industries and exposed to various regulatory regimes. So focused both on US federal and industry-specific legislation like HIPAA and GLBA, as well as state laws and international laws.
Perfect. So really excited to dive in today. Julie herself is actually located in Colorado, so she is in the thick of it of what we're going to be talking about and diving in through here. Just really briefly, for those of you that have not heard about the Constangy cyber team, we really do, we're spread out across the coast. We have colleagues that are on the West Coast, we have colleagues on the East Coast, and all in between, so we're able to really work with clients across a wide variety of different areas. As Julie said, we really work across a variety of different industries. We really have sort of three core groups here at Constangy Cyber. We focus on the incident response side, so helping companies to navigate incidents, whether that's a ransomware attack, whether it's a business email compromise, or the variety of other technical vulnerabilities that can come up. We also have an investigations and litigation group that works with companies to address a wide variety of cyber privacy and technology related litigation, whether that's class action litigation, business to business litigation, et cetera. And then Julie and myself, we sit in the compliance advisory group, working with companies to understand their regulatory obligations, identify gaps in those compliance programs that they have, or creating brand new compliance programs to address a wide variety of privacy, security, and technology controls that are increasingly required under these different regulations. So with that, really want to dive into the data privacy landscape, what it is that we're seeing at that really high level view before we talk really specifically about what we're seeing in Colorado. And so when we're looking at these core concepts, whether you're new to this area, you've been in this area for a long time, I think it's important to start by understanding, what do we mean by data security? What do we mean by data privacy? Because yes, they are aligned. Yes, there are commonalities between them, but oftentimes they're looking at different components of what's going on in your business. Data security is really around protecting your infrastructure. It's looking at your systems, your databases, and really looking to ensure that there's no unauthorized access or external actors or malicious actors that are able to compromise those systems. Oftentimes, what's in those systems has a data privacy component. But data privacy is not as focused per se on the security around the systems, although you certainly need that to have data privacy. It's really focused on the data and how businesses are using that data, how they're collecting it, how they're sharing it, how they're storing it. And privacy is really focused on personal data. And I think what's really been interesting to see evolve over the last decade is this broadening of what it can mean to have personal data. Obviously, things like your name, your email address, your phone number, those things sort of inherently feel like they have a personal data component to it. But as technology has evolved, as AI tools have just really increased the computing power, we see more and more types of data that are creating these privacy risks, that are becoming personal data that can impact a privacy component of your business. So again, data security and data privacy, they go hand in hand. They're going to walk side by side. They need to be talking within your business. But sometimes there's different focus points, there's different tension, there's different risks when you're looking at data security versus data privacy. And what we're going to see when we dive into some of the laws today is that while historically, especially in the United States, we had this big focus on data breach notification, the last 5 years has seen this rapid creation of data privacy laws focused on data, personal data, and the individuals who are behind that information. Really briefly, though, just on that security piece, I already stated it's protecting the data when we're looking at this. When we're thinking about data security and the data security landscape, you're really thinking about cybersecurity and technical controls that you have in place to protect that infrastructure. It's understanding how your back end is talking to each other, how you are protecting the information as it's flowing through your back end, and then also creating and maintaining an incident response plan, an incident response program. Because what we're increasingly seeing in today's world, and you hear this all the time in this space, it's not if you have a cybersecurity incident, it's when you have that cybersecurity incident. And minimizing your risk is really focusing on how quickly you can respond to that incident, identify those key parties as part of that incident, and mitigate the risks that you're seeing. So that's really what we're seeing from a data security perspective. Turning to the data privacy landscape, I like to think of this sort of from 3 different perspectives. The first is sort of what's going on internationally with the European Union and the general data protection regulation really continuing to drive a lot of what we see going on in that space. And then when we come to look sort of more what's going on in the United States, we have a federal component to it, and then we have state laws. And we're going to dive into sort of what that state law looks like. But I think the key thing when we're looking at the federal landscape is recognizing that as we sit here today, there is no comprehensive federal privacy law. We have certainly seen attempts at Congress to adopt some form of a comprehensive federal privacy law. To date, all of those have not been successful. And unfortunately, none have been able to move forward. So in sort of without that comprehensive law, it doesn't mean we don't have anything at the federal space. What we have is industry-specific laws. Healthcare and HIPAA are probably some of the most well-known privacy laws protecting protected healthcare information. We also have the Gramm-Leach-Bliley Act, which is focused on privacy in the business sector. This is why every year, if you have a bank account, you receive a privacy statement around what's being done with your information. We also have industry-specific standards like PCI DSS, which is dealing with the payment card industry. So anyone who is accepting American Express, Visa, MasterCard, etc., needs to comply with these industry standards or the PCI DSS standard, and a number of other different sort of industry approaches, etc. And then at the state level, we have increasingly a patchwork of state privacy laws. I think as we stand here today, we're up to 12 laws that have been passed, maybe 13. I think there's a few that are waiting for the governor's signature. But that has certainly been an area where we have seen a ton of movement, and we're going to talk through a couple of what those look like. So we talked through the GLBA, we talked through HIPAA. A couple other things just to mention at that federal privacy level. The Children's Online Privacy Protection Act, or COPA. This deals with the collection of children's data. It is enforced by the Federal Trade Commission, and is probably one of the more robustly enforced federal laws that we see. But again, focused exclusively on children's online privacy. And then just a brief mention on the FTC, or the Federal Trade Commission. The FTC has become a de facto privacy enforcement agency. Their enforcement derives from the FTC Act, and specifically the portion of the act that requires companies to avoid unfair or deceptive trade practices. And that's been expanded by the FTC to really create this privacy and security mandate. And they're really looking at outward-facing disclosures, what consumers are being told around privacy and security, reasonable security and privacy practices, and then holding businesses accountable for failing to comply or uphold those disclosures or those reasonable security and privacy practices. So the FTC has certainly been very influential in a lot of privacy decisions. We've seen them increasingly try to hold businesses accountable for different data security and privacy practices. But like I said, I think in the United States, that we really do focus more on the privacy laws. Before we do that, let's go ahead and we're going to throw out the hopping in with some quizzes that we want to make sure that folks are answering. So if we can go ahead and launch that first quiz. Question 1 is, the US maintains a comprehensive industry agnostic privacy law, true or false? So go ahead and answer that. And as you're answering it, we will continue to move on through here, talking about the state privacy laws. So as I said, the state privacy laws really are where a lot of the movement is currently happening at the United States. So we're going to give you some snapshots before we dive into Colorado, but you'll hear us reference this as we go through Colorado, so I think it's important to see. California really led the charge with the California Consumer Privacy Act, or the CCPA, went into effect in 2020. Since that time, it has been updated and revised in the California Consumer Privacy, or the California Privacy Rights Act. There's so many acronyms, it's sometimes very challenging. The CPRA, making updates and tweaks, etc. But California has really, to date, been probably one of the most dominant states in the privacy law space. But it is not the only state that we currently have that has an effective privacy law. As we sit here today, Virginia, Colorado, and Connecticut all have their own privacy laws that are in effect. Virginia went into effect January 1st of 2023. Colorado and Connecticut both went into effect July 1st, so just a week or so ago in this year. And then Utah will close us out this year, December 31st of 2023. Many of these laws do have some cure period, or they have some notice prior to enforcement that gives businesses a little bit of leeway when it comes to the enforcement provisions under these laws. A big update out of California was that their regulations, which provide additional color and requirements under the California Privacy Rights Act. They were intending to go into effect and be enforceable as of July 1st of this year. There was a court case we got a decision on June 30th that pushed back enforcement of those regulations until March 29th of 2024. However, this is not all of the CCPA that is pushed back to that enforcement. It is just those regulations that were adopted earlier this year. So the California Privacy Rights Act is enforceable right now. It's just that portions of it are only enforceable in March 29th of 2024. So this is the snapshot of what we're looking at this year. And if you are a business that is triggering one of these state privacy laws, you should be working towards, if not already compliant with, the requirements under that law. Now, looking forward into 2024 through 2026, and this does continue to evolve. In fact, June 30th, Delaware passed its own privacy law, waiting for the governor to sign that, and then we can sort of add it to this growing list of laws that we see that are going to be effective over the next 2 years. But you can see here, you have a little reprieve. July 1st of 2024 is when the next sort of wave of laws is going to go into effect, and that's Florida and Texas. Then you can see we sort of have these periodic rolling deadlines as we go forward with additional state privacy laws. And so what's really important to recognize is that even if today you may or may not be impacted by these state privacy laws, more and more states are adopting them. And it's really requiring many, many new businesses to understand the data they have, understand the regulatory requirements, and create some form of a privacy program to address these state privacy laws. And then just like other bills to watch for, Maine had been looking at its own comprehensive privacy law. This has not moved forward, but continues to be out there and sort of lingering. New Hampshire also in June had some movement as well. I think this is just continuing to reiterate that these states are all looking at adopting some form of a privacy law. So it's really within that backdrop that we see the Colorado Privacy Act requirements. And so, before we dive into the Colorado Privacy Act requirements, we have another poll question for you, which is question number 2, should have popped up for you. California is the only state with a currently effective privacy law, true or false? So we'll give you all some time to answer that. And I will turn this over to Julie, who is going to walk us through the Colorado Privacy Act requirements and what we're seeing specific to Colorado.
Thanks, Jordan. Can you hear me okay?
Yes.
Great. So we'll just quickly go through a little bit of background. As Jordan noted, I know, the participants come to this from various levels of understanding in terms of the detail of these laws. So in July 2021, SB 21190 was signed into law, and the Attorney General of Colorado was tasked with implementation and enforcement, as well as specifying rules, which they published in March. So we have the broad strokes of the law in the bill, but the rules give us details, guidelines for implementation, et cetera, similar to what we see across various laws. And those rules and the law were effective as of July 1st. And so we're just about 13 days in here. So a lot of our clients have been focused on complying with this law, and we still have folks, of course, who need assistance with that. So it's been a big focus over the last 6 months or so to get folks compliant with Colorado. So we'd like to give just sort of an overview here of in what case the Colorado Privacy Act applies. So the Colorado Privacy Act applies to the collection of personal data related to consumers. As you may know, all of the definitions of these different state laws can vary. Some are very similar, some are different, but we want to focus on the specific definitions in each law to understand where they are applicable and where they are not. So personal data in Colorado, their definition is similar to the definition we see in California and in Europe. Information that is linked or reasonably linkable to an identified or identifiable individual. So we're looking at an extremely broad definition here in Colorado as well, tracking some of those other privacy laws that have preceded Colorado. This does not include de-identified data or publicly available information. There is another category that is really important with respect to Colorado called sensitive data, which is sort of has some heightened requirements and standards, which we'll get into as well in Colorado. Comparable but different than sensitive personal information, which we see in California. So I think next slide, Jordan. So who does the CPA apply to? Controllers. So we're using a term you may be familiar with from the GDPR. This applies to folks who conduct business in Colorado or produce or deliver commercial products that are targeted to residents of Colorado. And so we've got both conducts business in Colorado or targets residents and does one of the following bullets you see here with the check marks next to them: controls or processes the personal data of 100,000 consumers or more during a calendar year annually, or derives revenue or receives a discount on the price of goods or services from the sale of personal data, and processes or controls the personal data of 25,000 consumers or more. So most of you or most of our clients are going to be concerned about whether or not you do business in Colorado. That's sort of an initial threshold, plus one of the sort of two additional triggers. And most likely we're focused on the first one. So do you control or process personal data of 100,000 consumers or more? Usually how we can tell that is, are we collecting personal data through websites, through user analytics, et cetera, or, for marketing purposes of 100,000 consumers or more. But this does apply to collection across the business. So it applies both to digital products, websites, as well as in-person collection or other methods of collection.
Yeah, and I think just to add on, Julie, to what Julie was saying, 100,000 is probably rather easy for a lot of businesses that have a web presence to get to, because if you are collecting even email addresses or some form of an identifier, if an individual is visiting your website, you could potentially be triggering sort of and counting up those consumers. So I think it's important to recognize that 100,000, yes, it's trying to create some form of a bar to make sure that you're getting to some more than a de minimis sort of collection of consumers. But because personal data is so broadly defined, it might be rather easy to get to that 100,000 consumers, more so than you might have thought even a few years ago, because of all the different tracking technologies and just the amount that individuals are doing with businesses online.
And another thing we want to think about is that while you want to do an analysis of whether or not you are a controller and the law applies directly to you, we also want to be cognizant that these requirements could apply to you through contract if you were doing business with a Colorado controller subject to the law. So we also see that. And we'll get to some of the contractual requirements here as well.
Julie,
So
before diving into the exemptions, we did have a question come in that I thought might be useful to address now. The question is revenue calculated annually from 25,000 consumers or in the aggregate? So I didn't know if you had any thoughts on that, because I think we want to make clear that revenue, I guess they're looking at this second check mark, but unlike California, there is no sort of revenue threshold per se for triggering the requirements of the law.
Yes, that's exactly right. So can you say the question exactly so I make sure that I'm responding to it directly?
Yes. So the question is revenue calculated annually from 25,000 consumers or in the aggregate?
Got it. Yes. So there's no revenue threshold, as Jordan said. The question is, do you derive revenue and process the personal data of 25,000 consumers or more? So really, it can be any amount of revenue or discount on the price of goods that you receive from the sale of personal data as that is defined under the law. Hopefully that clarifies it a little bit.
Perfect.
So the main exemptions here are PHI under HIPAA, clinical research, consumer reporting under the FCRA, GLBA protected personal data, COPA and FERPA. So we're talking about industry specific federal laws here that are, so student records, certain financial information related to financial institutions throughout the country, healthcare providers, etc. But some of the main ones that I want to call out here are employment records. So this is different from California. And so if you already have a privacy program related to California, this is something to consider, that Colorado does not apply to employment records. So controllers in their capacity as employers are, that particular data is not going to be subject to this law. However, unlike California, again, nonprofits are not exempted. So if you are a nonprofit entity and you otherwise meet the requirements, you still are subject to Colorado. So that's something, again, that's distinct from from California. And then covered entities and business associates, to the extent that you are a covered entity, you are not automatically exempted from this law, although the PHI that you hold is subject to HIPAA, but other personal data, which is, again, is a much broader definition than PHI, will be subject to the Colorado law.
Yeah, and Julie, just to add on to that, the Colorado Privacy Act takes a much more, I think, narrow approach than other privacy laws we see in the states around these exemptions. Because just like the HIPAA exemption, it's not if you're subject to HIPAA, you are exempted. It is the data that is subject to HIPAA is exempted. And the same thing is for the Gramm-Leach-Bliley Act, COPA, FERPA. And so for many businesses, only a portion of your data is actually going to be able to leverage these exemptions. Your business in total may trigger the CPA requirements because you're using non-exempted data, which is candidly more common than you would even realize. So I think it's important to just really emphasize that these are data specific exemptions and not entity level exemptions that we see under the act.
Yeah, absolutely. That's a really good point. We're seeing exemptions carved out of the definition of data as opposed to wholesale exemptions carved out under the definition of who this applies to, so of controllers. I think we can move to the next slide. Thanks so much. Okay, so let's dive in a little bit broadly at first here to the CPA requirements. And so I'll start sort of at the top right here. Respond to consumer rights requests. So in Colorado, we see some similar privacy rights afforded to consumers. Consumers, for example, have rights to access, correction, deletion, data portability, and opting out. Those are, we'll get into a little more in detail here in the presentation, but it's important to know that there are some similarities to what you'd see in California and other states now with Connecticut and Virginia and the other states sort of following suit in providing these privacy rights to consumers. You know, obviously the goal is to give visibility to consumers, to have accountability on controllers and businesses that are subject to these laws, and to put the consumer really more in the driver's seat in terms of managing and understanding what is being done with their data. So some similarities here, again, some distinctions. But what's important to think about here is that controllers have to respond to consumer requests within 45 days or without undue delay. That's in the original bill. So, you know, we have, businesses have to have, and nonprofits, I should say, controllers have to have mechanisms in place to be able to respond to those consumer rights requests within the allotted time. The privacy notice that you're required to have, which again, we'll get into a little bit, has to specify the methods that folks can make these consumer rights requests. And those methods have to be in a format that is similar to the way the controller normally interacts with the consumer. So here, you know, some of this, there's very specific language that the Colorado Privacy Act uses, that the various privacy laws use. But in sum, how we want to think about it is you have to not put up hurdles for consumers to make these rights requests. So for example, specifically, you're not permitted to force a consumer to create a user account if they don't already have one. You can ask them to sign into their account, but we have to think about what would be an unreasonable hurdle to make a request, and that's not acceptable. We also are required to make these rights just generally easy to execute. So in addition, like California, Colorado controllers are able to authenticate identity using commercially reasonable methods, is the language, to do so. Again, without a burdensome process, without collecting data that is not necessary to the authentication process. Next, we have here, going sort of in order clockwise, data protection assessments. So data protection assessments here, similar to what we see under the GDPR, in some ways, not exactly the same though. And in some cases, what we see a little bit under California, but these are kind of a bigger part, I think, of the Colorado Privacy Act, in that, and they're covered under Rule 8 in the rules, in that they're required anytime there is a heightened risk of harm to a consumer. Now, what does that mean? A heightened risk of harm to a consumer can be any unfair or deceptive treatment or disparate impact, something that might cause financial or physical injury or an intrusion into someone's privacy. But importantly, so those are sort of a little bit esoteric there. You really want to sort of, I think, use sort of a gut level here in terms of, how you're using data, what type of risk that might present to the consumer. But two areas that are specified in the bill that do automatically present a heightened risk are selling personal data and the processing of sensitive data. And again, we'll get into the definition of sensitive data a little bit. But if you're doing either of those things, a data protection assessment is actually required. What is a data protection assessment? So you're analyzing in a written form the risks to consumers, the measures to address those risks, to reduce or offset them that you could take, and the benefits of processing the data, and whether the benefits outweigh the risks. And obviously, if you're going to proceed with this data processing activity, you have to document this. They are required to be submitted to the Attorney General upon request within 30 days of that request. So this is a new requirement that you actually do want to pay attention to here if you're subject to the law. Secure processing and breach notification. So the law does require that you put in administrative, technical, and physical safeguards that are industry standard in order to protect data, and that you have breach notification policies and procedures and response. With respect to, we covered a little bit of that security piece when Jordan was discussing what is sort of good practice for a data security program. Here, the requirements aren't super detailed, but they are there. Contracts to govern processing of personal data. So we're going to jump to some detail on this in a moment, but you do have to have contracts in place with any third party that you're sharing this data with, or that has access to the data through you. And those contracts have to have very specific provisions in place to control those third parties and how they can use, share, transfer the data as well. Opt-out rights. So here, the opt-outs are going to look a little bit different. Again, the opt-out rights are specified in the bill and then clarified in the rules. So a consumer has the right to opt out in Colorado of the processing of personal data that is used for the purposes of targeted advertising, the sale of personal data, or the profiling in furtherance of decisions that produce legal or similarly significant effects concerning a consumer. Okay, so we all know what targeted advertising is at this point, although we can get into it if you'd like, and the sale of personal data, which we'll define as well. But this third one, profiling in furtherance of decisions that produce legal or similarly significant effects concerning a consumer. This is a new concept under Colorado, so it's worth just mentioning briefly. I think if you're concerned about this area, you're going to want to dig into it deeper in the future. But in effect, any decision that results in denial of financial or lending services, housing, insurance, education enrollment or opportunity, criminal justice, employment opportunities, healthcare services, or access to essential goods or services, that's considered a decision that produces legal or similarly significant effects. So any data used for that purpose, you have to provide an opt-out for. And we'll get to some of the specifics around opt-out in more detail as we go forward. Okay, Jordan, thanks. Anything to add, actually, Jordan, to that? That was a lot of information on that slide.
No, I think the key sort of takeaway is that the CPA, like many of the privacy laws, just have a number of these different requirements. And what we see at this state level is the law itself lays out certain of these requirements, but then those regulations that are often more nuanced, more specific, really are important to understand because they supplement and add that additional context and requirements of what's going to be necessary under these different laws. So I just wanted to highlight again, sort of Julie mentioned that, but you have sort of two sources of information that you want to be aware of when you're looking at the Colorado Privacy Act.
Great. So I'm going to not read these to you because you'll have access to this after our presentation. But it is important to know that, so we all use third parties for various things now, especially as we're increasing use of cloud providers to do various things within our business. We are often sharing data and data of all kinds, or we have folks, third parties that have access to our data. And so it's really important to know who your vendors are, who your third parties are, and make sure that you have data processing agreements in place, data processing addendums, whatever you want to call them. So most folks have these if they're already subject to California or certainly to the GDPR. But what we see with a lot of our clients is just kind of an ad hoc approach to contracting that is increasingly risky in the face of these laws, these additional state laws that are popping up. So you want to, if you have one, update your contract to comply with Colorado. Or if you don't have one, take a hard look at this, because this is a requirement that you, for everybody you're sharing data with, you have a written agreement that has these specific requirements in it. Some of, overall, you have to limit their ability to utilize the data to the limitations that you have agreed to with your consumer effectively through your privacy notice and otherwise. You have to make sure that they respect all of the opt-outs and other rights that the consumer has. And you have to, through this agreement, ensure that they have proper limitations for engaging other vendors and subcontractors, that they're passing down these requirements. Here, a couple things I want to point out. Your third parties are only allowed to engage a subcontractor after providing the controller with the opportunity to object. And that you have to have a written contract in place first, passing down these requirements. In addition, you have to carve out a requirement, or rather you have to assert a requirement that you can audit and inspect the use of information in the event that you would like to. So that is a requirement. I see some pushback there sometimes on auditing when you're seeing red lines. That is not optional here. So you're going to want to make sure you don't agree to any redlining and carve outs around audit rights and inspections. Anything to add there, Jordan?
No, I think you covered it all.
Okay. So consumer rights. So right to access specific information about the data that you as a controller are collecting, using, sharing, processing about an individual. Right to correction, right to correct any misinformation, right to deletion. So consumers have a right to ask you to delete all of the data that you controllers possess and are utilizing on you. There are some nuances around this. So there are some instances in which controllers do not have to delete everything they have on a consumer. So we want to you want to dig into the details on that. We're not going to focus too much on it today because there's some other big areas, and we have limited time, obviously, here, staring at the clock. Right to data portability, that means that when you provide data to a consumer, it has to be in a format that it can be readily transferred and utilized by another business or entity. So if the consumer wants to transfer that data to a different controller that is going to be providing a service to them, for example, you have to provide it to them in a format that's easy for them to do that and not put up hurdles there. And then right to opt out, again, we're going to jump into here in a moment, but I covered sort of what the rights to opt out focus on, which again, you're going to want to be thinking about sale of data and targeted advertising, which, you know, we hear a lot from clients saying, we don't sell data, we don't, you know, we don't really do targeted advertising. This often requires actually a little bit of a deeper dive with your marketing department, with your web developer to understand what is actually being done, because over the last 10, 15 plus years, actually the vast majority of businesses are in fact under the law selling data or sharing for targeted advertising. So that's important to know, and we can dive into that in a little more detail here too. Okay, so you have to have a privacy notice, as they call it here. A lot of people online call theirs a privacy policy. This does not have to be Colorado specific. It does have to be accessible through a conspicuous link on your website or otherwise posted if you interact with consumers in person. Imagine that these days, but some folks still do interact with consumers in person and not online. So, and this has to be posted and accessible before the collection of data. That's important to note as well. So similar requirements in California and in Europe with the notice at collection or just in time notice, as it's sometimes called. So you do have to have, you know, have this readily available to consumers. This privacy notice in Colorado, it has some distinct requirements, but it's mostly going to track what some other privacy notices are generally covering. So all of the categories of personal data processed, the purposes, the categories shared with third parties, the types of data shared, especially with respect to children and sensitive data, we're going to have to specify those separately. Whether or not the business sells personal data to third parties or processes it for targeted advertising or profiling or shares it for those purposes. All of the consumer rights and how to exercise those rights, how you can appeal, how you can contact the controller, etc. Some of the important things that you don't see specified on the slide is we really want to consider when privacy notices have to be when an update is made, when that we have to tell our consumers about that and in what format. Here, that is required when there's a material change. However, if there is what rises to what's called a secondary use under the Colorado law, and this is when you have really significantly changed some sort of way in which you are using consumer data, then you do have, that is not covered in your notice already, then there's actually a consent required for that change. So that's important to note here. Otherwise, you don't need a separate Colorado privacy policy, but you do need to probably edit your privacy policy to incorporate the Colorado specific requirements here, and to make sure that Colorado users understand, or Colorado consumers understand their rights and how to exercise them. Anything else, Jordan, on that one?
No, I just would, remind everyone that privacy policies now do require a little bit more in-depth analysis, more time than you might have ever spent on them before, because all of these laws have these very specific pieces of information that need to be included. There are similarities across the board, but they also need to remain relevant. And as your teams are rapidly changing their marketing strategies or the technology that they're using, it's important to make sure that there's a built-in process to reflect those changes in those outward-facing disclosures, like a privacy notice.
Great. And I'm going to just spend the next couple minutes highlighting very specific items from the Colorado Privacy Act that I think are kind of the most important to focus on, so that I can leave you with about 5 minutes for strategies of implementation here. So let's cover consent. So this is an important piece to the Colorado Privacy Act that is different and distinct from other laws. So consent, clear affirmative act signifying a consumer is freely given specific, informed, and unambiguous agreement to the processing of data in a specific way. So the rules are very specific about what each of these things means: specific, informed, unanimous, or unambiguous agreement. So we're going to want to go there and be really detailed about our understanding there. But what it means is consent does not include acceptance of the privacy policy in whole. So general or broad terms. It cannot be, you cannot include consent with other terms and conditions, for example, that folks consent to when they come on the website. If we're talking about for example, a cookies banner, hovering over, muting, pausing, or closing it, Xing it out, or clicking on dismiss does not constitute consent under the law, or agreeing through dark patterns. So there are some concepts that are built into the rules as well as the law, but on dark patterns and choice architecture that you're going to want to consider in case folks here don't know what dark patterns are, because why would you if you're not a web developer? But these are specifically mechanisms that are built into websites that are designed to impact the way a user engages with the website or to manipulate their decision making. So one of the main examples that folks use all the time is sort of a countdown clock that tells a consumer, you have 30 seconds to take advantage of this discount or something like that. But that's not real, right? The discount's not actually going to evaporate in 30 seconds. That is the type of thing that's called a dark pattern. Over the last several years, of course, developers have gotten really good at integrating these mechanisms. Privacy laws don't like them. Okay, so it has to be clear. And when do we need consent? Let's hop to the next slide. Okay, so consent is required. The big one here is the top one: processing of sensitive data. And let's actually just hop to what sensitive data is, Jordan, on the next slide, since I want to really highlight this, since this is in effect right now. So sensitive data includes data that could reveal racial or ethnic background, religious beliefs, mental or physical health condition or diagnosis, sex life or sexual orientation, citizenship or citizenship status, genetic or biometric data processed to identify an individual, as well as any data of a child. But that is a whole other category. If you have children's data, if you're targeting your product towards children as consumers, you have, other requirements under this law that are important. Okay, so these are the categories that if you are collecting right now, data that could reveal these items, a consent is required to collect it before the time of collection, period. This is different than California, which is a pure opt-out rule. So this is something you really want to consider. Now, there aren't a ton of consumer-facing businesses that necessarily need this type of information, but if you are collecting it, you do require a separate, specific consent. And that consent has to tell folks precisely what you're doing with that information, who you're sharing it with, and for what purposes. Okay. So if actually, Jordan, if we can pop back to that other slide, and then I'll turn it back over to you. The other items that you want to consider here are consent is going to be required for selling personal data or processing personal data for targeted advertising in the event that someone has opted out of those things, including through the universal opt-out mechanism. So with that, let's hop to the universal opt-out mechanism. And this is the last thing we'll say on Colorado. So the universal opt-out mechanism requirements under the Colorado law are also new and innovative in Colorado. It is designed to encourage developers and folks to come up with universal opt-out mechanisms that go across websites. So we're looking, for example, here at, for example, the global privacy control or other mechanisms that are sort of in development that allow users to go and select under their browser or otherwise a setting that effectively says, I opt out of sale and targeted advertising collection of my data. I opt out. And what Colorado is saying is it is not an option for controllers to not respect that opt-out as it has been previously, arguably, possibly, under other state laws. So they're very specific about this. They have technical specifications for what a universal opt-out mechanism is and what is required. Important for you all to know, this goes into effect January 1st, 2024. So we're not there. I'm sorry, July 1st, 2024. So we're not there yet. And the Colorado Department of Law has to actually publish a public list of what is included in the universal opt-out mechanisms in Colorado, which ones we recognize here in Colorado on January 1st of 2024. This is going to be a big thing coming down the pike. Okay, Jordan, I will turn it over to you to sort of wrap us up, and sorry for talking so much.
No, that was incredibly comprehensive, super helpful. And I think it just highlights really, why it's important to both look at these laws individually, but then also in the context of all the various states that you might be working in, just to understand what is and what is not required. So I know we're coming up on the end of our hour. Just wanted to briefly highlight, some key privacy risks to be thinking about beyond the Colorado Privacy Act, which is really increased activity from state attorney generals. We're just seeing more and more AG's offices focusing on data breaches, consumer rights, and making sure that businesses are adequately addressing the risks that are presented by the way that they're collecting data, the processing of that data, and then any sharing of that data. As I highlighted earlier on, the FTC enforcement has certainly upticked and continues to take different approaches to encouraging businesses to implement those reasonable security and privacy protections. Data protection authorities are very common within the European Union, but with the California Privacy Protection Agency, we now have in California a standalone privacy agency that is enforcing solely the California privacy rights and the act. So important to recognize that there's multiple different ways in which regulators can get involved in enforcing privacy. And then as consumers become more aware of their data, the impact of technology, their own rights, we do see this loss of consumer trust or brand reputation impact, especially in the cyber breach context, or where you're unable to respond to those consumers when they're asking around certain privacy rights. So some key things to be focusing under the CPA, if you've not already been diving into it, I think these are some good places to start, which is looking at your consent mechanisms under the CPA, As Julie highlighted, there are some specific nuances that Colorado presents around active versus passive consent. There are those very specific contractual requirements that Julie covered, making sure that you have those contractual provisions in place between controllers and processors, reviewing any past agreements, seeing if you have to update them, amend them, and then coming up with sort of documents going forward that can be used to address that. And then conducting those protection impact assessments to identify when you have privacy risks and then what steps you need to be taking. So we really appreciate you joining us today. Hopefully you were able to take away some really helpful tidbits around the Colorado Privacy Act. We welcome you to reach out to myself, Julie, any of our other team members with any questions, whether related to the Colorado privacy laws or other US state privacy laws, national or international movements that we see in this space. As we highlighted, we're going to be making these slides available in a recording of this presentation, but definitely welcome you reaching out to us with any further questions. But with that, we will go ahead and end the presentation today and really appreciate everyone joining us.